Perfect. All right. So I'm going to be going over the offer forms today. I will tell you that I will try to look at the chat, but if you ask a question there and I don't get to it, raise your hand or feel free to chime in. You're welcome to interrupt as we go. We can also do a Q&A at the end. And as I get through each form, I'll see if you have any questions. So if you have a question, don't hesitate to ask it because chances are if you have it, somebody else is thinking that too. There's also no shame if you are a very experienced agent and you have a question that you think seems very basic, that's okay. Because again, if you have that question, chances are someone else will too. I've tried to anticipate what questions people may have, but I may not have thought of everything. So feel free to chime in as we go along. I'm going to try to move through at a pretty good pace to get through everything. But at the same time, the point of doing this session is to give you a deeper understanding of the forms. So I will try to touch on things that are important. I'll try to go through all of the paragraphs that are significant or relevant and kind of talk about things beyond just the words on the page. So bear with me, but again, if you have questions, feel free to chime in. All right, let me share our screen and then we'll get started. All right, so what I'm going to do is I'm going to leave the offer to purchase for the end because that's the biggest form here, the most to kind of talk about. But I'm going to go through some other forms that you may be using as part of your offer process or contracts that maybe you aren't using very often. So you may not even really know they exist, or maybe you aren't reviewing them very often. So the first thing I'm going to start with is these custom amendments that we have from Sterling Law. And this is relating to either the address, the buyer's name, or the seller's name. Because what can happen sometimes is you get all the way to closing or right before closing, and the lender says, oh, by the way, the zip code on the offer to purchase on the contract has the wrong number. It's 275. It says 27511, but it's actually 27513. And nobody caught it along the way, but then you're scrambling right at the end to make a change. Or maybe the buyer is actually a junior and you forgot to put the JR on the end. And a lender, when they catch that, is going to require that change. They don't want anything out of order. And so oftentimes then you're scrambling, okay, well, how do I do that? Do I scratch through the offer to purchase and just make that change? Well, does that have any implications on the effective date of the contract? We don't want to do anything that puts it at risk there. So we had Sterling just create these really simple amendments to the offer where you can change the address, change a seller name, or change a buyer name. Now, this is intended for kind of like minor typographical misspellings, things like that. So just know that we have these. These are in the master folder in .loop. This is the one for changing an address. This is the one for changing a seller name. And this is the one for changing a buyer name. So the one on the buyer also gives you the opportunity to change who the deed is being made out to. That may or may not be necessary the way that paragraph is actually written, but that option is there for you if you need it. So just want to make sure you guys are aware of those. Any questions about that? Because I'm going to touch on when we get later to the agreement to amend contract, North Carolina has actually added options on there, if you haven't looked at it in a while, to add or remove a buyer or seller or to add an additional buyer. So I'll talk more about that. This is more for just making a change to the name. Any questions? All right, cool. And as I'm thinking about this too, again, if you put something in the chat, I may or may not see it, but if you raise your hand, if you use the little emoji to raise your hand, that will move you to the top of my screen where I see everybody's picture. So do that if you want to chime in on something. All right, next thing I'm going to jump on is the cooperative compensation form. I'm going to talk more about this than I really want to because there's a good chance that come July 1st, compensation is just going to be in our offer and we won't need this form anymore. But just in case North Carolina Forms Committee decides to kick the can on this and they like reverse course and say, no, we're not ready to put it in the offer yet, then you still need to be prepared to use this. And even though we've had this now for, I don't know, what, 2 years, 2.5 years, however long it's been since the NAR settlement, there's still lots of questions and confusion around this. So I just want to touch on a couple things. First, most important note, Do not put anything about compensation in the MLS. They are still getting violations of that. I mean, you can't, don't try to be sneaky. Don't try to put it in a different language. Don't try to use some kind of like World War II type code. Don't link to a Google Drive box or Dropbox or Google Drive, and that has it in there. If somebody can access what the compensation is through the MLS or something connected to the MLS, like showing time, then you're in violation. Not only can you get fined and suspended from the MLS, but that can put you and the firm at risk of not being covered by the settlement, which means all of a sudden we could get sued. You could get sued in a major way. So let's not mess with that. They are using like AI to help catch those, but we just don't want to risk it slipping through. Um, so as far as listing agents go, and again, if you have a question or comment on this, please feel free to chime in. But if you're a listing agent, you still have the option. You can do this in advance and provide it to a buyer. So you can have some kind of automation set up. So when somebody schedules a showing, they automatically get an email from you. Again, not through showing time. You have to set up a different trigger. It has to come from a different way. It can't come from showing time. But you could set something up. You could just email it. You could have copies of these in the listing if you wanted to. So all of that is perfectly fine. If the seller is setting an amount they want to pay up front, then great, you can do it. Just remember, you can only check this box for seller. Choice does not agree to pay compensation through the firm ever. We've changed our listing agreement so that that's not even an option for you. So it's always going to be the seller that's offering it. So you have that option as a listing agent. There is also the option to just tell a buyer's agent, yep, seller's happy to pay compensation. Just send over your form 220 and we'll negotiate it. You can do that too. So you don't have to set it up front as a listing agent. That's up to you. The other thing is that as a buyer's agent, even if a listing agent gives you one of these, and we are all presumably choice agents here, so I can actually use a real number and not get in trouble here. So let's say that a listing agent sends you a 220 with 2% as the buyer agent compensation, and you're like, well, my buyer agent compensation with my agreement with my buyer is 3%. You're allowed to just write up a new 220 and submit that with your offer. Okay, you just itemize it in the contract. It doesn't matter that the seller sent you one, the listing agent sent you one. You send whatever you want and you attach it to your offer, and the buyer has signed it, and you're now sending that over as a term of the offer. If you're going to do that, if it's different, because it could be higher or lower, the listing agent could send you one that says 3%, and your compensation in your agreement with your buyer is 2.5%. So you could be sending one over that's actually lower than what the seller had said they'd be willing to pay. Just let the agent know ahead of time, hey, FYI, we sent this over. Because what'll end up happening, and I hear this all the time, is that the listing agent will say, yep, seller agrees to your offer, except here's the form 220. And it's different than what you submitted. And they just act like it's a matter of fact. Like, oh, nope, you asked for 2.5, but the seller is actually paying 2.4. So here you go. Here's this one. You guys need to sign that one. Well, your offer didn't offer 2.4, you offered 2.5. So the seller has rejected your offer and have countered back by saying I would pay 2.4. So just be aware that sometimes listing agents act like just because the seller and they set that number up front, that is written in stone. Remember, the reason this form exists is because buyer agent compensation is negotiable. So you and your buyer get to offer whatever you and your buyer decide to offer. Don't let a listing agent convince you that just because the seller has said that is written in stone. Now, seller may draw a hard line and they're only going to offer 2.4 and they don't care what you submit to them. That's fine. That's a conversation for you and your buyer to decide if you're going to charge that difference to your buyer or if that's going to change what the buyer wants to offer, so on and so forth. Let me make sure I've touched on everything. Make sure you itemize it in the offer. So check the box. I'll show you this when we go over the offer. Check the box for other addenda and write form 220 in there, at least for now. Again, this all may be a moot point in 2 months. Okay, remember, if you are writing this as a buyer's agent and you don't know yet, you're just making your offer, you don't know what the seller is doing, you don't know if the seller is paying it or the listing agent is paying it or listing firm, Just by default, my suggestion is check the box for seller. So if you're a buyer agent, you're writing this, you haven't received anything from the listing agent yet, just check the box for seller. Most firms, especially large firms, have gone uh, to where their policies state that they aren't going to be involved with the commission. And the reason is we don't want to be involved in a dispute. If we get to closing day and the seller walks into the attorney's office and tells the attorney, "Hey, remove that buyer agent compensation," which they can do that. I mean, contractually they're going to be obligated that they sign this, but they can walk into the attorney's office and say, "No, I'm not signing that closing disclosure until you remove that buyer agent compensation." The attorney is going to remove it because our compensation can't get in the way of a buyer and seller completing their transaction. But we don't want that buyer agent firm to be able to come after us for it because we want nothing in the paperwork to say we had anything to do with it. We want that buyer agent firm to have to sue the seller. All right. That's why we do that, in case you were wondering. Couple notes here. If you look at paragraph 2, the fee is only payable if the property closes. So just remember that. It's technically earned once you go under contract, but it's never payable unless the property closes. So your seller can rest easy on that. And then as far as this date here for paragraph 3, sometimes people still stumble on that. Just put a date that's beyond what you expect to close, just to be safe. But really, the only thing that matters is that it's beyond the date that you go under contract. Once you go under contract, it is earned, and that the fact that it has been earned will extend forever until the property closes or is terminated. But just to be on the safe side, I would put a date in here that is, a week past, a month past, whatever your anticipated closing date. Just whatever you do, make sure it's passed when when the property goes under contract. All right, that's all I have on 220. Any questions there? And I only see three screens. So if you do have a question and you can't find the hand raise button, just unmute yourself and talk. But I have notes, so you're not going to like throw me off. I'll be able to regain where I was. All right, next thing I'm going to jump to then, if there's no questions on Form 220.
Hey,
Did you have a question,
Brian?
Michael?
Yeah. Kind of just to clarify, because you said it and it seemed rather important as I heard it. So if you send a contract over and the contract has a Form 220, and whatever the number is that you're asking for the buyer agent compensation, if you get a signed contract back, but there's a different Form 220 because the seller is agreeing to a different amount than what you had requested, then in fact, you don't have a contract at all. You have a counteroffer. That's what you said, right?
Correct. The offer was rejected. And the seller basically proposed new terms. That would be no different than them coming back and saying, you asked for 5,000 in closing cost. I'm willing to do 2,500.
Gotcha. So until you have that part of it ironed out, that seller is free to accept another offer. Am I correct?
Correct.
Okay. All right.
That's where this will become way more obvious once it's just another line item in the offer to purchase. But think of the compensation as just a term of the offer, just like price, due diligence fee, concessions, closing date is just another term. But it is important that you itemize it in the offer because a lot of forms will have a statement at the top that says this form is made part of the offer to purchase between these two parties for this address. This form doesn't have that. So you can't just have this floating out in space. It needs to be attached to the offer by being itemized there. So you'll notice like the due diligence request and agreement document that, for example, when you complete that, the reason it doesn't have to be itemized is because it automatically becomes part of the contract that you're talking about just by having everybody sign it. So this is an important one. Make sure you itemize it. We still see agents sending it over. They'll send over the offer and they'll send this over, but it's not itemized in the offer. And the reason is there are a lot of agents that still believe it's illegal to include our compensation as part of the offer. That is not true. North Carolina changed that law, but a lot of agents don't realize that. A lot of firms don't talk about that, so they won't itemize it. But they have then put themselves at risk because the seller could just sign the offer and not sign this, and then they don't owe anything to the buyer agent.
Gotcha.
Uh,
Thank you.
Vanessa.
You answered my question. I
Oh,
had not made it a practice to itemize it in the additional addenda, so I'll just make that a habit moving forward.
perfect. It may be a short-lived habit because come
Right,
July, it hopefully will be in the offer.
right.
Vanessa Franco, you're up.
When you were talking about the term, the date, the agreement will terminate. So if the date, the original date was like a cash transaction, so it was going to be easy, but then the days change, you go back and change this, or you just leave it?
Nope. Nope. You can just leave it because all you need in practice, all you need in reality is for this date to be on or after the date you go under contract. You could close a year later after this date, and that's okay. The fee has been earned and it's payable at closing, whenever closing occurs. I'm just saying as a best practice, if you're making an offer and closing is 30 days away, make this date 60 days away just to be safe. Nobody's at risk. The seller is not at risk of having to pay something if they don't sell to this buyer. It is only earned when this buyer and this seller go under contract together, but then it will extend on through closing whenever that occurs. Great. All right, Marilyn.
Brian, I have hard time seeing that date before you move on. What date is it?
It's this paragraph 3. So this is the date that this agreement will terminate. It will expire on that date if you haven't gone under contract yet. Marilyn.
Yes, just to get back to including what the compensation agreement is with an offer, what you just went over and that Vanessa had a confirm, but can you review that one more time? I'm still not 100% clear on how to do that.
I tell you what, then I'm going to go out of order here,
Okay,
and I'm going to jump over to the offer to purchase. So what you'll do here, paragraph 14, where you would itemize any other addenda, you're going to check this box that says identify other attorney or party drafted addenda, and check that box, and you're going to write Form 220
gotcha. Okay.
or
And then
cooperating
just
compensation agreement or whatever.
include.
But
Mhm.
that makes it a term of the offer now, just like any of these other ones would. Yeah.
That makes a lot of sense because it was kind of
So,
in in between, not complete before.
yeah. And again, I don't know what it was it last year, or the year before, North Carolina. You lose track of time when you have young children, track of years. But it used to be illegal for you to include your compensation in the offer to purchase, but that was changed at the legislative level in North Carolina. So it is now part of the general statute. You can, in fact, include compensation as part of the offer. This is how we now do it.
Perfect. Thank you.
You got it. All right. If you think of anything else related to that, we can always come back and revisit it. All right, let's talk real quick about the new construction offer to purchase. This is Form 800T. So you really won't use this a ton. Most new construction you sell, the builders are going to have their own contract. However, there are plenty of smaller builders. Most custom builders who are really established are also going to have their own contracts. They may only build 20 houses a year, but chances are they've had an attorney create their own contract. But there are plenty that don't. And when they don't, if they don't have their own custom contract, you're going to use this new construction offer to purchase. You're going to use this when the house is not substantially complete. So let's ask the audience here. If the house is framed and the roof is on it and no drywall, is that substantially complete? All right. Well, I only see two faces. I'm sure all of you are shaking your head, so that's good. No, it's not substantially complete. What if there was drywall? Nope, still not substantial. Yeah, nobody wanted to commit themselves there. Yeah. Oh, some people are shaking their head. Yeah. No, drywall doesn't fit. I mean, substantially complete means like the house is done. Maybe the CEO is not issued yet. Maybe they still have to do some touch-up painting, but the house is done. I mean, there's no question as to what's going in. The hardware is there, the floors are in, the lighting is there, the deck is built, the house is done, right? For all intents and purposes, the house is done. If there's really a dispute about it, fine, let's talk about it. Typically, you'll know, is the house finished or is it not finished? Let me read this first part of this offer. Again, because this doesn't, I don't want to spend a ton of time on it because it doesn't come up much and you may not use it for the next 2 years and you're not going to remember what I said anyway, but I do want it to be in your brain that this form is here and that you need to just read through it in the moment that you're going to be using it. And you probably need to read through it 3 or 4 times to make sure you understand what it's saying. But it's important that this is not you don't use this like if the buyer owns the land already, they're buying a piece of land and they're contracting with a builder. That's not what this is for. They're going to sign a building contract with that contractor, that general contractor. This is when a seller owns a property and they are either the builder themselves or they're hiring a builder to build a house and they're going to be selling it. And the reason it's important that you use the new construction offer to purchase versus the standard offer to purchase. I mean, so much of this is the same or similar to the standard 2T, but there's language in the new construction contract that talks about a pre-construction evaluation period. It references plans and specifications. It has a construction fee schedule, and it talks about warranties that the builder is obligated to. So think about this, a standard offer to purchase, where does it talk about what the builder is obligated to after closing? It doesn't, right? Because you're buying it from just another individual. It's a resale property. So this is new construction, the first time the property is changing hands, that the real property of the house is changing hands. And so by this contract, the seller has an obligation for a 1-year workmanship warranty. So that's in this contract. By the way, if you're working with a small builder, you better be really clear about what that follow-up is after year one or during year one. Because just because it's in this contract, I mean, the buyer, if the builder doesn't really live up to their end of the bargain, the buyer is going to have to sue them, and you're going to go after them in court to fix these cracks in the drywall and this creaking floor or whatever the other things are that could come up. So you want to make sure you have an understanding if you're dealing with a small builder, and usually if you're using this form, you're dealing with a small builder about what is their commitment after closing. So again, I'm breezing through this form. It is 16 pages long, so it's not one I would normally want to breeze through, other than I know you're not using it a lot. But do you guys have any specific questions about it? That you have looked at it before, you've had it in the past, you've had issues. If it is completely new form to you, I don't want to take up all of the session going over this form. And so what I would tell you is that this is completely new form to you, just for your own knowledge. Go through and read this once or twice so that you can be familiar with what is a pre-construction evaluation period. Think of that as your due diligence period, but this is, determining that what you want done can be done on the property. All right, so I will move on from this. If anybody has questions, great, but I would just encourage you, go back and make it a point to like, oh, I didn't even know we had a new construction form. Great, now you know, now you can go look at it. Related to this is the new construction addendum. So this is to be used when it is new construction. Oh, was there a
I have a
question?
quick question.
Oh,
So
yeah.
we use that form only if the builder does not have any new construction, any form or any offer to purchase.
Correct. Yeah, you're not going to try to fight a builder and say, no, we're not willing to use your custom offer or contract. We're going to use this one. I mean, if the buyer wanted to take that stance, they could. It's the buyer's decision. But if a builder has a contract, you're going to use their contract. If you're going to have them build a house for you, you're going to use their contract. Now, just side note, thank you for mentioning that. We are expected to be experts on this form, on 800T, okay? Because that's a state provided form. We are not expected to be experts on a custom builder form. So when you get that, I would encourage you to run it through Choice AI and say, hey, what provisions here do I need to make sure I highlight for the buyer? Are there any things for them to be concerned about? Are there any red flags here? have AI help you start to address that. But if a buyer has a specific question about a custom builder contract, you have to defer them to an attorney. These big builders, their contracts can be 40, 50, 60 pages. Come on, we didn't go to law school. So we don't want to get stuck in the middle of trying to decipher what all of that means. AI is a great tool for us to give us good talking points, but you always have to tell a buyer, hey, look, if you have specific questions about their offer, like I've reviewed it, it looks pretty standard, but there is no such thing as standard when it comes to new construction. So, if you have any questions or concerns, you need to run it through an attorney. But yeah.
Brian, I use one. I think we have. I sent a question via our group with AI when I was gonna write up an offer for a new construction for a small builder. But what I was advised in our group chat is that I can use the standard offer to purchase, but add a new construction addendum. That's what I did. So was
Yep.
that to put this form instead?
So remember, the new construction offer to purchase, Form 800T, is for when the house is not substantially complete. The new construction addendum is for when it is substantially complete. So there's no reason to have talk about a pre-construction evaluation period when the house is already basically done. So then you just put this new construction addendum in. What this does is it adds in, the main thing it's doing here is it's adding in the language about warranties. And it gives you an opportunity that if there's something else the buyer wants done, let's say they want custom shelves in the primary closet, or they want a second concrete patio poured, or something like that, you can add that in here, and it gives you an opportunity to make if you had a building deposit, that would go towards the builder's cost for having to do those improvements. So that's what this does. So yes, I don't remember or know the situation specifically you're talking about. But if the house is materially done, you would use a standard offer to purchase and the new construction addendum. That's the main delineation.
Yeah, you're right. The house we were making an offer on was substantially completed. So I've done it right.
Perfect. Good. Marilyn.
So you're saying we don't, so if the builder has their own contract, we're not going to use the addendum. What I normally do is just write it up in an email, our terms, what we're requesting. But you're saying we could use this form instead of just.
No, you wouldn't. If they have their own contract, it'd probably require a change order. So they should have their own way of documenting that. But yes, before you're actually submitting a written offer or completing their contract, you will have talked about, hey, this is what the buyer wants done. Builder will tell you whether they're willing to do it or not, what it's going to cost, and they should handle that with a change order or something similar.
Right. Okay. That sounds great.
Yeah.
Thank you.
But only use this if you're using it with Form 2T. That's what it's intended for.
Okay. Great. Thank you.
Mm-hmm. All right. We will move on. Let's talk about the additional provisions addendum. All right, a few things I want to touch on. This you will itemize this just like I showed you where you would put Form 220. You will itemize it, but this is one of those forms, like I mentioned a minute ago. This addendum is attached to and made part of the offer to purchase and contract between seller and buyer for the property. So even if you somehow slipped up and had a lapse in judgment or forgot and you didn't itemize it, chances are you're going to be okay by the buyer, assuming the buyer and seller sign this document. Now, if you send this over and along with the offer, and the seller only signs the offer, not this, and you didn't itemize it, that's not a great place to be, because the seller agreed to your offer. They didn't agree to this addendum, but the addendum wasn't made part of the offer because the seller never signed it. But just be aware that as long as everybody signs it, even if you forgot to itemize it, the listing agent can't come back, or seller can't come back later and say, oh, you forgot to check this box in paragraph 14 on the offer to purchase, so therefore this no longer applies. That's not true. Once the seller signed this, the buyer signed it, of course, already. Once the seller signed it, it became part of that contract. Okay, so just want to point that out. There's another nuance that I'll get to when I go over the offer to purchase that agents get confused about when something is valid, if a signature was missed or whatever. So we'll talk more about that later. All right, so paragraph one, pretty straightforward. You put a date in there and a time, and when this is the expiration of the offer. When that comes and goes, the offer is expired. But what is important is that if the offer expires and then the seller comes back an hour later, a day later, it doesn't matter, a minute later, and says, you know what, we will go ahead and accept your offer. Here you go. Here's the signed contract back. Too bad. It doesn't work that way. The contract became expired. It went up in flames. It wasn't there, metaphorically speaking, to be signed anymore. It didn't exist anymore. It wasn't on the table anymore. It was expired. And so if the seller comes back and says, okay, here you go, here's a signed contract, you say, okay, well, let me talk to the buyer to see if they want to resubmit their terms because our offer expired and you will need to submit a new one. Even if the buyer says, oh, good, like they want the seller to accept it, it doesn't matter. They need to submit a new offer and have that signed by the seller because if it ever came up, if there was a dispute later on, once an attorney gets involved, they start looking at the timestamps on everything and they'll say, wait a second, we never had a contract. That offer was void. So seller can get out of this or the buyer can get out of this. And we never actually had a contract in the first place. So none of the terms of the contract actually matter. So you don't want to fall on that. The timing of it really matters. So just be aware of that. Paragraph 2, it's going to be rare that you're ever going to need this. If you are going to be using this section, this is about a septic system installation. You will have talked to the seller and the listing agent about the circumstances because the seller is going to have to clear land. I mean, it's going to be, it's a thing you will have discussed if you're going to be selecting this second paragraph number 2, option number 2 here. So I'm not going to dive into that. Call me if you ever have to deal with that. Number 3, though, is very relevant. It's not uncommon that you might sell a property that has a tenant in it. It is important that you include this as part of that offer if there is a tenant. Now, even if you don't include it, certain things are going to happen anyway. That lease still applies. So your buyer still has to honor that lease, regardless of whether you included this form or not. But this form does some specific and important things, which it requires the seller to provide copies of the lease, for example. It requires the seller to tell you if there's any past due rent. It determines if there's a pet fee, if that is going to transfer to the buyer or not at closing. So it does some things that are important if the property is rented. Make sure you realize this is here and you are including that. Anything else? Oh, so yes, there are a couple other things. If you're including any repairs or improvements, so let's say, there's a hole in the wall in the living room and you want that fixed because I don't know, I guess you could argue it, but that's mostly cosmetic. And so if it was that way when your buyer made the offer, seller's probably not going to be obligated to fix that hole unless you spell that out in the offer. Okay. But what I want to caution you on is as you are writing this stuff up, and it could be any number of things. I mean, we don't see these a lot, but if you're writing it up, you need to be like obnoxiously specific about what the buyer is asking the seller to do. And if you have any question, you need to think about what you're writing and say, is there a way somebody could interpret this differently than the way that I intend it? Are there any gaps in clarity here? And if you're unsure, get an attorney involved. Obviously have me or have the broker in charge review it and kind of give you some feedback on it. Make sure that the buyer has reviewed it and approves what is being written, not just by them signing this form. Them signing it is not enough to say that, yes, I read it, I understood it, and that's the language I want in there. You need to have an email with that buyer saying, hey, here's what I'm thinking of sending over based on what you told me. Take a look at it. Let me know if you're okay with that. If you think any changes are needed, we don't want there to be any confusion. So this needs to be exactly what you want. And they need to respond to you and tell you, yes, that's what I want. Send it over with the offer. Because chances are you're the one that wrote this. And so just because they signed it, if there's a problem later, they're going to say, well, you're the one that wrote it. I was relying on you to know what to put in there. And we want to avoid that at all costs. Michael.
Is it possible maybe to add an initial in that box, maybe in the lower corner, so that they're actually initialing like the bottom of the corner of the box that you wrote in what would be
Yeah.
repaired for buyer and seller?
I mean, you certainly could. You could throw that in. I mean, one of the things I used to do with all of my buyer clients at closing was have them initial a copy of the survey to prove at closing that they saw and that we reviewed the survey with them. I learned that from a paralegal many, many years ago to do that. So you could do that. But here's the thing. So I'll give you kind of an example that's a different situation. If there's a complaint to the real estate commission and I get pulled into it as the broker in charge, and let's say you as an agent, you did something wrong. Let's say that you mismeasured a house and the square footage was wrong, okay? And there's a complaint, and they're going to pull me in on something like that. And what they're going to ask me is they're going to say, okay, well, actually, you know what? Let me give you an even better example. Due diligence fee being refundable. All right. Well, we know it's non-refundable. It's in the offer. It's in the contract. It says it's not refundable. It's very clear. But if a consumer files a complaint because they wanted to get their money back after they terminated and they couldn't, and they're like, well, my agent didn't tell me that. And the commission, they file a complaint, commission's going to reach out to you and they're going to say, where did you tell the buyer that the due diligence fee was non-refundable? And you're going to pull out the offer and you're going to say, well, here, they signed this. I mean, look, they initialed this page. It says the due diligence fee is non-refundable. They're going to say, no, 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 no. What did you do to make sure the buyer understood that the due diligence fee was non-refundable? And if all you did was present a 14-page contract that has 70 million words on it, and they initialed the bottom of that page, that is insufficient to prove that you explained clearly that the due diligence fee was non-refundable. So when I look at things like this, you know, a buyer wants all this stuff done. They give you 17 things that they want the seller to do as part of the offer, and they want you to write it up. I don't like that just an initial or a signature. I want a written paper trail of, yes, I have reviewed this language that we are submitting. This is my wording. This is what I want, and I approve it. Because if something goes wrong later, that's just going to give you so much more protection. So what I'll say is always, this is an aside, as an agent, I know this is the way I think, always assume, no matter how well the transaction is going, that eventually that client is going to turn on you and try to sue you. And what have you done to protect your interests? Okay. So you don't have to be, it doesn't have to be like a sad way to live your life or to run your business. It is just a reality. I have a friend who was an agent. I'll be brief on this. A friend who's an agent. He sold a house in downtown Cary. There's a railroad track that runs through downtown Cary. The house was relatively close to the railroad track. The agent had done everything. This is not meant to scare you. This is just meant to tell you the reality of the world we live in. Had done everything to disclose to this buyer that the proximity to the railroad track, including having the buyer initial a map that showed the house in relation to the railroad track. Guess what? After closing, the buyer sued the agent, admitted, yes, you told me the railroad track was there, but you didn't tell me how much of a nuisance the noise was going to be. You didn't explain clearly enough what that nuisance was going to be. So then E&O insurance gets involved, and this client happened to be an attorney. They knew how to play the game. And so the insurance company said, we're just going to settle. We're going to pay him some money to go away because it's not worth fighting it in court. And so even when you do everything you can, sometimes you can't win for losing, right? But you want to take as many precautions. That is an outlier, but you want to take as many precautions as you can to make sure you have documented everything along the way. How you have interacted with past clients matters, right? If you can pull in 10 other past clients of yours and they all say, yeah, he clearly explained to me that the due diligence fee was non-refundable, great. That goes a long way to defending yourself. So, all right. Sorry for that aside, but thank you for the question. Vanessa.
So one extra measure that I do for that is when I review the offer to purchase with them, at the buyer consultation specifically, is I highlight that section. I have a printed copy. I'm old school, and I have a printed copy because it just, you never know, right? And so when I do send the documents to them, I their buyer agency documents and I have the sample offer to purchase, I also get them to initial that little area right next to that part of the sample offer to purchase, because it's just little things where whatever, even in a residential property disclosure, for example, the one that I have under contract with Heather, there was something in the disclosure that I wanted my client to be extra sure they knew that. So I put initials there, even though there's not a spot for them, it at least shows me that they got to that part, right? So I agree with you.
Yeah, I shared an example on a daily video in the past of a cemetery that was was adjacent to a property. There was a permanent easement that was granted to get to that cemetery. That the map showing that cemetery there and the easement was included in the documents section of the MLS listing. But when taken to court, it was determined that that was insufficient to make sure the buyer was aware of it. Just putting it in the documents section. So have buyers sign, initial everything, have an email chain going with the agent. Clarity is king. So don't just sneak it in there somewhere. All right, beat that horse enough. Paragraph 5, manufactured home. On the offer to purchase, there is a box you would check if there is a manufactured home. If that box is being checked, yes, then make sure you have the information here in section 5. Section 6, this is really important. Our area has more pools than it did prior to COVID. Pools all of a sudden became popular here and actually add value to the house. Isn't that nice? But it's important that you check this box because this determines who is responsible for getting the pool ready to be inspected and then re-winterizing it if it was wintertime, if it's winterized. If you don't fill this out, it is going to be the buyer's responsibility. So if the seller was never going to be willing to do it themselves anyway, fine, it's going to be the buyer's by default. But I would suggest when you're making an offer, you would check this box that says seller is responsible for re-winterizing the property, the pool, to make it available for inspections and to re-winterize it. So just know that that is there. By the way, side note on that, it is important to make sure this is a good reminder that your clients know they have the right to have a pool or spa inspected. There are companies that will do that inspection. If it's a pool, that seems really obvious. That seems like a big thing. But if there's just a hot tub sitting out on a concrete pad in the backyard, that's a spa. And if that's conveying with the house, the buyer has the right to have that inspected. What you don't want to do is have the buyer get in that hot tub after a long day of moving into the house and to find out it doesn't work. And now they're saying, oh, it doesn't work. We had this happen before, by the way. They call the company out to come fix it. And the tech says, well, didn't you have it inspected? Oh, no, my agent never told me I should have the hot tub inspected. Okay, now all of a sudden you, the agent, may be on the hook for paying for that repair. So make sure they know they can have that stuff inspected. And then just paragraph 7, again, you're probably never going to deal with it. It's very rare if you are dealing with an offsite septic or boat slip or something like that. There are some neighborhoods, like there's one out in Sanford where they have a lake and people can have boat slips and stuff. And I'm sure there are others. Just make sure you're getting clarity with the agent. And if there's any questions, reach out to your broker in charge or an attorney to get some guidance to make sure there's nothing weird there. So any questions about the additional provisions addendum? Cool. All right. Moving on, backup contract. This is another one people don't use often. Once upon a time we did. It was used to be used a lot more often, but haven't seen it much lately. But this is actually a really good one to use. I think it's a value add for your buyers, and I think it's a value add as a listing agent to be encouraging other agents to consider that, to encourage their buyers to consider it anyway. So this is for use when you contract and the buyer wants to be in the backup position, meaning if that first contract falls through, they automatically become the primary contract. They become the buyer. The house doesn't go back on the market. A buyer would want that because they don't want it to go back on the market and maybe have to compete with somebody else. They just want that house if the first buyer walks for whatever reason. A seller may want it because they may also not want to have to go back on the market and have showings, but also that backup offer might be better than the primary offer they have. Well, that would be really enticing. By the way, another little side note here, as a buyer's agent, you don't know if the seller accepted a backup offer. So you better be aware on how you're negotiating during this transaction. You want to take some hard line and the seller's like, see ya. I have a better offer waiting in the wing that's giving me a gajillion dollars in due diligence money. I hope you walk, Mr. and Mrs. Buyer. So just be aware, you never know. But being in a backup position as a buyer is good for that reason. If your backup offer is better than the one the seller has, you're giving the seller a lot of incentive to not play nicely with the current buyer. And you're increasing the chances that first contract could fall through just by virtue of you being in backup position. Because the seller has less incentive to cooperate with repair negotiations or a appraisal shortfall or something like that. So being in backup position is good. By the way, you can withdraw that at any time. It is an informal process to withdraw your backup offer. You just send the listing agent a text or an email and say, buyer has pulled their backup offer, and that instant it's done. Nobody has to sign anything. You just need that paper trail. You need written notice that they've pulled it back. All right, let's go through it real quick though to make sure we touch on all the highlights here, and let me know if you have any questions. So you need the last name of the buyer. So right here, it's not a paragraph number, but right here at the top, you will need the last name of the primary buyer. That's how you identify what that primary contract is. So that part is important.
I have a question, Brian.
Oh yeah.
What if, yes, you have a backup contract? You want to be first in line if the first contract fails. However, you want to know the reason why that failed, and you want to see that in writing or some form before you can, be the second one in line. How can you make that happen? Because it can be, because the buyer has done the inspection and they found something really bad and that the seller refused. Yeah.
I got you.
How
Yep,
do you
I got you.
your
I'll get to that in just a second. We're going to get there. All right. But first, let me say the backup offer only goes into primary position if the primary contract is terminated. That's what paragraph 1 talks about. Paragraph 2 talks about what does terminated mean? What are the methods that contract could be terminated, therefore allowing the backup offer to come into play. Paragraph 3, the buyer is held the buyer is held harmless if the seller basically lies and says, yep, that contract, the primary contract was terminated. You as the buyer go under contract, you close on the house, and now there's a lawsuit. The buyer is held harmless there. They didn't do anything wrong. That's paragraph 3. Paragraph 4 basically says any changes to the primary contract, that doesn't constitute a termination. So they extend the closing date, they change the price. That's not a termination. The backup buyer cannot review the primary contract, but they do need to know, they don't have the right to review that primary contract, but they do have a right to know when it's going to close. So you'll list that here in paragraph 5, when the scheduled closing date is. Again, that can change, and that doesn't put the backup buyer into primary position, but the backup buyer has a right to know when it's expected to close. The paragraph 6, the backup contract automatically terminates if the primary contract closes. So it doesn't just live on in perpetuity. It will automatically terminate itself once the primary contract closes. And then paragraph 7 describes how notice can be given to the buyer if the primary contract terminates. They do not have to provide you with a copy of the termination. So just be aware of that. You can ask for it, and it's probably a good practice to ask for it. It definitely is a good practice to say, great, send me over that form 350 or 390 to show me. And if they send it to you, great. If they don't have to. They just have to give you written notice that contract is terminated, and you have to rely on that written notice. And that can be an email or text message, right? Just written notice. There's not a form they're going to send you that says, now you are officially the primary contract. They're going to call you or email you and say, hey, you're now the primary contract. And that's going to then trigger dates and stuff that we'll talk about in a second.
What is Form 350 again? Sorry, what is Form 350 again?
350 and 390, those are termination forms.
Oh, okay.
Yep. So to Maria's point about, well, what if the primary buyer had an inspection done, they back out, and now the listing agent is emailing me to tell me, hey, congratulations, your buyer is now the primary buyer. Your very next question should be, well, that's great. Why did the primary buyer walk away? Were there any inspections done? And is there anything that you and the seller are aware of now that you were not aware of at the time that we made our backup offer that the buyer needs to know? So you need to ask those questions. If new material facts, new information was discovered through an inspection or whatever, survey, anything that now the seller knows, they are obligated. It doesn't say this in this addendum, but I've spoken to attorneys about it. They have an obligation to now share this new information with the buyer, and the buyer then has an opportunity to say, yeah, you know what, I'm not going to move forward with it. They have an opportunity to withdraw the backup offer at that time. So the way the backup offer addendum is written is not at any way intended to allow a seller to just slide in there and trap that second buyer. If there's new information, absolutely buyer has the right to know it. They have the right then to evaluate whether or not they want to move forward. But you need to ask those questions. Don't try to bring this up 2 weeks later after the buyers have had their inspections done and delivered due diligence money and earnest money and so on and so forth. You need to be asking those questions immediately once the listing agent tells you that, hey, you're now primary. Like, let's pump the brakes for a second. That's great, but I need to know this additional information. Does that help? Okay.
Yeah.
All right. Oh, okay, good. So paragraph 8 talks about the fees and the dates associated with it. So when you're doing a backup offer, always do additional earnest money. You don't want to, initial earnest money is going to be due at the time that your backup offer is accepted. That's just kind of annoying logistically. Why should the buyer have money come out of their account while we're waiting to see if we're ever going to become primary? So if you do additional earnest money, you don't have to worry about that. That's only going to be due at a future date. So the way the dates are handled, because you don't know when and if you're going to ever become primary. So additional earnest money, which normally on the offer to purchase, you're going to put a date when that is due. And typically you do what? You line it up with when the due diligence period is ending. But in the case of a backup offer, you're going to put a number of days. So if you can see my screen, I just highlighted right here. So 5 p.m. on a date that is blank number of days after you became primary. Okay. So if you're I would encourage you to just have that line up with your due diligence period, or even better, like a day or two later. Now, the only thing, and I'll talk about this when I go over the offer in a minute, the only thing to be aware of here is that you don't know what day you're going to become primary. And so you put 21 days here, that might fall on a Saturday, right? Or a Sunday. Well, you're not going to be able to go to the attorney's office and drop off the earnest money on a Saturday or Sunday. So just be aware of that, because time is of the essence when it comes to delivery of additional earnest money. So if you need to get it there on a Friday because the deadline is actually Saturday or Sunday, then you need to do that. So just be aware of this. There's no option here to pick a date because we don't know what the starting point is going to be. Due diligence fee is not due when you make the offer. It's due 2 days after you've been moved into primary status. Okay, that's when due diligence fee is due. The due diligence period has the same method as the additional earnest money, a number of days following the receipt of notice that you are now primary contract. Settlement date is going to be the same thing. So for all of these, be aware that the date may fall on a weekend because you don't know what the starting point is yet. That's an important nuance. Yes, Maria Luisa.
But okay, I have a question after that.
Oh no, you go ahead.
Okay, why would can you explain to me the difference between the initial earnest money and additional earnest money, just so I can see what I because I usually offer we have the due diligence money, and then I think after that there is earnest money, and then I skip that. I skip the additional earnest money because I want to line
So
up.
let me come back to that. Let me come back to this when I get to the offer to purchase. All right, we'll come back to that because
Okay,
that's part of the offer to purchase. So
very
we'll just
good.
move through. Yeah, perfect. All right. Anything else I want to touch on here? Oh, well, I've already mentioned it, but the buyer can terminate this at any point. There's no form you need. That's one of the biggest confusion points is what form do I send to withdraw my backup offer? There is no form. You just send an email, a text message, whatever, and just say we're withdrawing it. And then there is a automatic termination here in paragraph 10. So if you just want this backup contract to have, you're like, hey, I'll give it 2 weeks. If it hasn't fallen through, I'm out, and I don't want to have to remember to terminate it later. Great, you can put an automatic termination in here. All right, so that's it. Any other questions on specifically on the backup offer? And I'll get to the earnest money in a second. Excellent. All right, let's jump into the agreement to amend contract, 4T. All right.
Hey, Brian, sorry,
Yep.
Brian, I'm late to raise my hand, but I have a question about the backup offer. So what you mentioned earlier at the beginning is, okay, so there's this buyer who found this home kind of late and it's already under contract, but like desperately want it or whatever. So in that case, as a buyer's agent, can I reach out to the seller's agent? Hey, are you willing to take a backup offer? And then send a backup offer. Of course, we don't know what the price they get, but we guess and kind of offer higher than listing price and try to kind of motivate the seller and let the deal fall through. Is that what you said?
Yeah. Yeah, absolutely. And look, I've had sellers accept backup offers that are less than the current contract just because they don't want any, if it falls through, they just want another one. They don't want to go back on the market. You know, maybe they've moved out or or maybe they have kids. It doesn't matter what the reason is. So you don't have, your backup offer doesn't have to be higher. It's just a negotiation. You make a backup offer, seller can counter. As a listing agent, encourage this. Don't be turned off from backup offers. If you get one that's not as good, tell the seller, like, counter them. You know, if you're willing to accept a backup offer that's higher than your current contract, counter them at that. It doesn't matter. They can say no, but encourage that negotiation for the backup offer. Yeah, as a listing agent, it's a great thing.
So also, it would be probably possible if my buyer lost in multiple offer and later they regret not making a higher offer. And they say, hey, if they are willing to take a backup offer, I could make it higher and make
That's
a
right.
backup offer.
Absolutely. Yeah, you can do that. I mean, set proper expectations. Most contracts don't fall through. Most of the time, you find your way to the closing table. But it does throw another little nuance to it if a seller has a backup offer that's higher than the current offer. You know, it makes them feel a heck of a lot more empowered to stand firm during repair negotiations if they know they've got somebody in the wings. Just keep in mind that backup offer can be pulled at any moment. So you don't want a seller to be too confident. Oh yeah, I'm going to let these first buyers walk because I got these other people. Well, by the time the first buyers send the termination over, the backup people may have pulled their offer. So timing is important, by the way, on all things real estate. But if your buyer tells you to pull the backup offer, don't wait until after your yoga session or you're out of the movie or send that email, that text message that moment. Because inevitably, if your buyer tells you they want to pull it and you say, okay, great, and then you're going to wait an hour to send that notice to the listing agent, it is Murphy's Law. The listing agent is going to email you and put you into primary position, and your buyer is going to owe that due diligence fee. So be very timely with that.
All right. Thank you.
Absolutely. All right. Agreement to amend contract. First thing I want to say is that you can have as many of these as you want. You can have 75,000 amendments. That is okay, right? Now, realistically, you're going to have one or two or three or four, but I'm just saying you can have any number. You have the ability to put this number up here. This was added a couple years ago. It is so nice that it's easier now to determine what order these amendments were in, because now we have a little number spot up here where we can number the amendment. It used to be you had to look at when everybody signed it to determine what the order was. This makes it much easier. Now, when you create a second amendment, that does not void the first amendment. Okay? Amendment number 7 doesn't get rid of amendment number 6 or number 1 or any of the other ones. However, if you are changing the same term, that's different, right? So if your list price is 500,000, your contract price is 500,000, and you do an amendment to change the price right here, and you change it from 500 to 490. Okay, now our contract price is 490 on amendment number 1. And then you do amendment number 2 and change it from 490 to 480. your price is 480. Okay. Yes, the First Amendment got washed out because you changed the exact same term. However, if that First Amendment also changed the seller paid closing cost, the expenses, if it also changed that, okay, but on your Second Amendment, all you did was change the price again, this part still is intact, okay? So you didn't lose the fact that you had changed the expenses on Amendment 1, because creating a Second Amendment doesn't eliminate the First Amendment. It just eliminates if you are changing the same term that was on the First Amendment. But any unchanged terms that were on that First Amendment still exist. They're still there. They're still amended. Any questions on that? Because oftentimes we don't do this a lot, and so you're not forced to think through the logistics of that. But once you do, it makes sense. All right, good. All right, let me just point out quickly again about the names, because this was added, I don't know if it was added last year or maybe it's been a couple of years now, I don't remember. But you can now add an additional buyer really easily here, and you can remove a buyer and seller really easily here. You'll notice the one thing it doesn't have is adding a seller. To be honest, I'm not really sure why it doesn't. I hope that come July 1st, a new version of this will come out and allows you to add a seller. In the meantime, if you needed to, you could just use this Sterling Amendment. Seller name shall hereby read as, and you could just add this additional seller. An important note is that when you're adding or removing a buyer or seller, everybody has to sign it. If you are in this example here, you're adding a buyer, checking this box, additional buyer, and you're adding this buyer to the contract. You're adding me. Brian Horgan is being added to Michael Puckett's, the purchase he was making. Now I'm also making it with him. You're going to put my name here. I'm going to sign this document, and so is Michael. And of course, the sellers are too. I don't have to, Brian Horgan, who was just added, I don't have to go back and sign everything else that's been signed. By virtue of my name being here and me signing this document, I am saying I'm agreeing to all the terms that are related to this contract. So I better sure as heck have reviewed all the terms related to this contract. But the only thing the new buyer needs to sign is this, not everything else. It's kind of similar to like the additional signatures addendum, if anybody's ever used that. We're not going over that one today. That one's actually straightforward if you just read it. But anyway. All right, anything else I want to touch on here? Oh, yes. The settlement, most of this is straightforward, but the settlement date is important. There's an option here for changing the closing date. You can check this box. Hopefully we all know that we have a 7-day cushion to delay closing. Buyer and seller each get that cushion. If you check this box when you are changing the closing date, it reduces that cushion to 4 days. So just be aware, there's no standard practice, whatever the buyer and seller agree to. But the idea is, all right, I'm the seller. I'm going to let the buyer delay because of whatever lender problem they have. But man, I don't want to give them an extra 7 days beyond that. This gives you the ability to just say, okay, well, I'm only going to give them an extra 4 days. And yes, you do have the right to, if you want to move the closing date to July 31st and check this box for 4 days, you could actually change the closing date to July 27th. Right? If you're saying, I'll give the buyer until the 31st to close, but I don't want to give them a cushion beyond that, then you would change the date to July 27th, check the box for 4 days, and then closing date will come and go on the 27th, and the buyer is now in their cushion. And if they don't close by the 31st, the seller can terminate after that. And then just one other quick note about the escrow agent. Remember, escrow agent, it does not equal closing attorney. Escrow agent is who is holding the earnest money. Usually it's the closing attorney, but it can't be choice because we don't have a trust account, but it could be a listing firm or a buyer agent firm, or it could just be some other attorney. 99 times out of 100, it's going to be the closing attorney, but you can actually change that here. So if the escrow agent was the closing attorney and then the buyer changed their mind, they want to use a different attorney, that new attorney is going to need the earnest money deposit. So this is how you do that. You change the escrow agent. This is an acknowledgement that the first attorney can send it to the new attorney, and the new attorney is signing saying, now I'm in possession of that earnest money. questions on additional provisions, or excuse me, agreement to amend contract? All right, we get to the offer to purchase. We're a little after 11, so thank you for hanging with me. I will go through this as quickly as I can, but the point here is to make sure you have all your questions answered. So let's make sure that we do that. First thing, make sure when it comes to the property details, you are putting in as much as you can. Please don't be lazy. It helps to determine if there could be a possible discrepancy. If you are taking the time to go through and get more than just the street address, make sure you're understanding the lot number, the section, the phase, the subdivision, the PIN number, the looking at the register of deeds and making sure you've got the book and page. You know, we require a copy of the deed with our listing paperwork. The reason is to force you to have to go look at it and make sure everything lines up correctly. So this is all there for a reason. Even though it doesn't happen often, it can it can help you determine if there's an issue with the way the property is listed or the address. So please take the time to fill all of that out. The additional parcels, so sometimes you might sell, especially like older homes, like you could be selling this 1950s ranch in Zebulon, and there's an empty lot next to it that's just been part of the house forever since like 200 years ago when the family that divided the farmland up and whatever. So if there's a separate lot, you can itemize that, hey, I'm selling this house and it's coming with the empty lot next door. It's coming together as one package. You would check this box saying that there are additional parcels. The exhibit can be really simple, just exhibit A, and list the address. I mean, all the information that you would put up here for this property, try to put it for that additional parcel. This is not really meant that if somebody's selling, 4 rental properties, you're not doing that, right? You either need to have 4 separate contracts or you need to have one contract with an attorney drafted addendum that binds all of those together. So this is meant for like the more straightforward stuff of selling a house and there's a vacant lot that's coming with it, something like that. Okay. All right. Another little best practice here. Make sure you are either putting NA or zeros. And like I would do like 0.00 on any blanks that you're not filling in here. Don't leave them empty. That goes for every blank in the contract, but especially for ones that deal with money. Don't leave them blank. Talking about initial versus additional earnest money. Initial earnest money obviously is due at the very beginning. It's not at risk yet for the buyer. So my opinion, and it is only an opinion, is that what's the point in doing initial earnest money? The buyer doesn't know if they're going to actually buy the house yet. They're still conducting their due diligence. Let's wait until they know they're going to buy the house to make them write that earnest money check. That would be the argument for doing additional earnest money. Notice that additional is in parentheses. That means that you don't have to have initial in order to have additional. It is just earnest money that is due later. That's not as good of a title saying earned by earnest money that is due later, right? So you're not going to write that in there, but that's what that is. Additional is in parentheses for a reason. It means there does not have to be initial earnest money in order to have additional earnest money. It is really important to know that time is of the essence with this additional earnest money. That is the reason not to do it. Now, if it's me, if I'm writing an offer, I'm doing additional earnest money like every single time, right? But it means that you now have a really important date that you have to remember and help the buyer remember. Because if that date comes and goes, if 5 p.m. on that date comes and goes, the buyer's in breach of contract. The seller can terminate the contract unilaterally at 5:01 on that date if the buyer had not delivered earnest money to the escrow agent. So when you're doing additional earnest money, set a reminder, put it on your calendar, make sure it's on the buyer's calendar, invite them to a calendar event so that they have it on their calendar as well. Have a plan in place so that the buyer is not out of town or they think they can wire it to the attorney, but turns out they have to actually go into their bank to initiate a wire. Sometimes that happens. Have a plan because there is no bend on this. Time is of the essence there. It's really critical, really important. The other thing I'll say is on all of these options, they give you multiple formats in which this can be paid, the due diligence fee and earnest money. If you don't know exactly precisely how the buyer is going to be paying that, check multiple boxes. Give them multiple options on how they can pay that. You might think they're going to pay it by personal check. Turns out the buyer is 25 years old and they don't have a checkbook. So they can't write a personal check. Well, guess what? If they go try to get a bank check and that box isn't checked, they're not adhering to the terms of the contract. That could put your buyer in breach. So if you aren't sure, check all of them. Any questions about that? And Maria Luisa, did I answer your question about earnest money? All right. If I didn't, speak up. One more note about additional earnest money. Common practice is that you will put it as this, it's due the same date that due diligence ends. I would advise you as a buyer's agent, give it another day, another banking day. So if due diligence ends on a Friday, don't make it due on Saturday, make it due on Monday. Make sure Monday is not Martin Luther King Day, right? Make sure it's not a bank holiday, okay? So have it due on the next bank day. Now, you may get pushback from a listing agent, fine. That's what we do for a living is negotiate. So fine, negotiate it. But how often does the repair negotiations come down to the wire? And you're trying to get signatures at 4:58. And the buyer doesn't want to deliver their earnest money until they know they've got agreement on the repairs. And so then you get repairs agreed to, but then at 5:01, your buyer's in breach because they didn't get the earnest money there in time. So it is good practice. You don't have to be worried as a listing agent. The additional earnest money is due. It is non-refundable when the due diligence period ends, even if it hasn't been delivered to the escrow agent. It's still non-refundable. The buyer still owes it if they terminate the contract. Okay. So you don't have to really worry. I mean, obviously, as a listing agent, it's better if it's already at the attorney's office, but the buyer owes it no matter what when the due diligence period ends, even if the date that it has to be delivered is after the due diligence period ends. Okay. Any questions about that? It makes sense in my head, but I want to make sure it makes sense in your head. All right. Moving on, seller concessions. Again, make sure to NA. Make sure to NA that if you're not putting anything in there. The other thing is make sure that the amount is not more than the buyer can use. Please talk to your lender, the buyer's lender, and make sure that you're not putting more than a buyer can actually use for closing costs, because there's no guarantee that your buyer will get to use that extra money. There's a good chance it'll go back to the seller. Let's talk about the pros and cons here with putting either a date in for due diligence period or a number of days. I probably have changed my tune on this a little bit, although I don't know. I used to think that putting a number of days in was better because it guaranteed you a set amount of time to conduct your due diligence. Negotiations may drag on for a few days. And then by the time you get that signed contract back, now you've lost a few days in your due diligence period, right? If you had put a date in there. The downside is if you put a number of days, that could end on a Saturday or a Sunday, or it could end on a Friday that you're on a cruise ship or whatever. And that's not fun. So I probably lean more towards putting a date in there now, or if you are putting a number of days, make sure you are editing that based on the day that you're going to be going under contract to say, hey, my intention is 21 days, but I don't want it to fall on a Saturday. We need to modify that because we've taken 3 days to negotiate this out. Jen DeCourcy.
Hey, one thing someone said on Facebook, and I've been noticing too, is I've been seeing a lot more of agents just offering due diligence and not offering earnest money as well. So when that comes into play, let's say that they offered $8,000 due diligence, no earnest money. At the end of the day, the date is immaterial, right? If it's 10 days, 14 days, 21 days, all the way to closing, whatever, the due diligence is the due diligence. So I had like an agent say, they had all due diligence, no earnest money. And then they said, well, we need to have an agreement by the end of due diligence.
That's right.
And if not, let's extend the due diligence period.
Yep.
I'm like, why? There's no point.
So I want all choice agents to be the most educated on this. I think you all are, but that is what she said is correct. The only implication, if there's no earnest money, the only implication of the due diligence period expiring is that the buyer owes their agent the compensation. Because if the buyer were to terminate after due diligence ends, the buyer is in breach of contract. Now, as far as the seller is concerned, the only remedy there is that they get to keep the due diligence fee and earnest money. In this case, the earnest money, there is none. So that's the only impact for the seller. So nothing changes on that end. But the buyer, per our agency agreement, says if they breach the contract, they owe us the commission. Hopefully you will have a conversation with your buyer. And if you're going to be charging them that compensation, you're letting them know that before. You're not telling them, oh, there's no earnest money, it doesn't matter. And then they terminate and you turn around and say, oh, but you owe me my commission. No, I'm not going to have your back on that. You need to have told them that is an implication. But you're absolutely right. Gently, kindly educate the other side and tell them, hey, I know the seller is eager to get this wrapped up. We are too, but remember, there's no earnest money. So the due diligence date actually doesn't have an impact on our contract, on the buyer and seller's contract together. Let's keep at this. Let's see if we can get everybody in agreement, right? So yes, take that approach. Agents by default, they are just trained. You got to do everything before due diligence ends. You'll get listing agents that think that buyers can't have inspections done after due diligence ends. Wrong. Buyer can conduct due diligence through closing. Don't give the due diligence date more weight than it deserves. It's important, but it's all relative to how the contract is structured. One other quick thing here, and then Michael, I'll get to you. Do not ever put NA in here. Because what does NA mean? Does NA mean the due diligence period is expired or that the due diligence period extends forever? We don't know. So don't put NA in there. You need to have a date. If the goal is to not have a due diligence period, great. Put the date of the contract. Michael.
In listening to this, I guess I look at it twofold. If you're on the side of the buyer, that sounds great. Up until the day of closing, if I want to cancel this contract, I'm out my due diligence money, whatever. Flip side, if I'm representing the seller, however, I kind of want a due diligence date because typically the due diligence date is, say, within 14 days or so of the contract date, but closing might be 30, 45, 60 days away. So I've got another, 30 plus days maybe between the end of due diligence and closing. And that 30-day period is when the seller is really like, okay, due diligence is over. Now I'm making plans. I got to move. I got to get out of here. And I don't want to find out 2 days before closing that the buyers decided to cancel the contract and boom.
So you make a good point, but what your point actually is not about the due diligence date. It's about the need to have earnest money in the contract. And so that's what, as listing agents, you need to be thinking about. I don't care. Oh, they gave me $50,000 in due diligence. Great. You better make sure your seller understands it doesn't matter if they terminate tomorrow or the morning of closing. The $50,000 is what you're getting. Are you okay with that? Are you okay that your life just turned upside down because you moved all your furniture out and you're staying in Airbnb? Are you okay that you have $50,000 to show for it? And if the answer is yes, then the earnest money doesn't matter. If the answer is, well, no, like if those fools back out on me the morning of closing, I need an extra 25 grand. Great. Then you better counter back with 25 grand in earnest money, right? So that's where the earnest money comes in. I think it's less about the due diligence period. Just think of it this way. It does not matter unless there's earnest money. That is not 100% true, but for all intents and purposes, it doesn't matter unless there's earnest money. The main impact of the due diligence date is making the earnest money non-refundable. Vanessa Mouton.
And actually, Jessica answered it before. I was going to ask you to speak to what question was in the chat, which was, what if negotiations take longer than you have less days for due diligence? And I had responded, just update the offer. But the key is there's not really a form for it. And how do you handle that if you started with a date and it took 3 days extra? You just update the offer. I mean, I'm not a fan of strike throughs personally. So if you would speak to that, I like fresh documents. So
3 days longer to what?
To negotiate the contract itself. So if you set a date of,
correct.
Let's say
Update
June 10th, and it took 3 days or 4 days, you still want the extra 4 days. How do you fix that? You just update the offer and stay in communication with that listing agent that's what you're intending to do.
That's right. If you negotiated for 3 days, chances are you need to submit a new offer anyway, right? Obviously, if the seller was sitting on the offer for 3 days, then as a buyer's agent and they haven't responded yet, as a
Mhm.
buyer's agent, you need to pull that offer and submit a new one, right?
Right.
I mean, because if the seller sends back a signed contract 3 days later, you're stuck with those dates that are in there.
Right.
So you better be monitoring that. You get past 24 hours, maybe 48 hours, you better make sure those dates still work for your buyer. Yeah.
100%.
Settlement date. Only thing I'll just mention here: try to avoid Fridays, try to avoid Mondays whenever you can. Pay attention to holidays. Pay attention to travel schedules. Oftentimes that you don't realize it till a week before closing. And it's like, oh, the buyer is actually going to be on a cruise. Why didn't we talk about that before? So think about that. Again, escrow agent is not the. I'm going to keep moving quickly, but please raise your hand or chime in if I say something that doesn't make sense to you. The escrow agent is not necessarily the closing attorney, but 99 times out of 100, it is. If there is earnest money, you need an escrow agent in here. If there is not earnest money, you do not need an escrow agent listed here. You can NA this if there's no earnest money. I know that is going to give some people heartburn because they think this is the closing attorney. This is not the closing attorney. Read the paragraph. That's what you tell the other side if they get
I like
upset
the
about
heartburn message.
it. Yeah. Tell them to read the paragraph. Look, this is what we tell you guys. When you guys call us with questions, and we don't really do this, but sometimes maybe we say, well, go read the contract and call me back and let me know if you still have your question. Go
Brian,
read paragraph 7.
can I
Yeah.
give a tip that an agent gave a long time ago? I don't even remember how many years it's been now. If you are an agent, and obviously everybody on here is an agent, but if you have never sat down and read the offer to purchase out loud, sit down and do it. And her joke was that she would do it before bed so that it would make her sleepy. But inevitably, she would find parts of the contract that she didn't really understand, and it gave her an opportunity to ask questions. It is really good to read it because once you have done it out loud specifically, it brings up things and then it allows you to explain it to your buyers and sellers better too.
Absolutely. That's right. We should read this often. Ashley and I do this still to this day. When we get questions, we will go back and read the language, make sure we understand the nuance of it. And I've read these things, I don't even know how many times, but they
Yeah.
also change every year. So you've got to be the thing that you thought you knew changed 2 years ago. Oh, and you forgot to join my update session that I'll do in July. And so you didn't catch that change. And 2 years later, you think it was still the same way it was. So yeah, read it frequently. Here's another good reason to read it: the effective date. Okay, this section right here, sub paragraph J. You know what this says? Among other things, it says that missing a set of initials does not invalidate the contract. Did you know that? Did you know that if they forget to sign initial page 2, but they signed at the end, the contract is still valid and enforceable? Well, in case you were ever wondering where that's written, it's written right here, buried in subparagraph J, effective date, right? Who would think to read that section? But that's important. There's a lot of things we talk about, like it doesn't matter. Just know that one piece because you will get kickback from an agent that says, we're not under contract yet. You didn't initial page 7. We do need to initial page 7. That's important for my liability with my buyer. I need evidence that my buyer reviewed that page. That's what them initialing is doing, is saying, I reviewed this page. So I want my buyer to initial that. But as far as the buyer and seller are concerned, they still have an enforceable contract. Another note: due diligence fee can be paid to someone else other than the seller. There is no form for that. But if the listing agent tells you, don't make it out to the seller, make it out to the seller's mother, you as a buyer agent / buyer have an obligation to follow that command. You don't get to say, no, I'm going to do it to the seller. You don't like it, too bad. No, it doesn't work that way. Whatever the seller and listing agent tells you, that's what you do. I hope they will put a blank in here on the new form that allows a seller to include who it's going to be made out to. But until that time, if they email you, you have to listen to them and do it that way. Now, by the way, that person has to be cooperative. So if you were going to be wiring the money, for example, that person, whoever it is, not the seller, still has to be cooperative to receive that money. They can't not give you the wire instructions and then say, ha, you didn't send us the due diligence fee in time. Now you're in breach. So just know that. All right, let's shoot down to paragraph 2. The rest of this, yeah, read it, but we know. But I want to touch on fixtures. Just because something is advertised in the MLS or on a flyer or in a phone call or in an email, that does not make it part of the contract. That is not enforceable. Whatever is in the contract is going to be what a judge would say, well, I don't care what y'all talked about before. This clearly is what the buyer and seller were agreeing to because this is what they put in their contract and what they signed. I don't care what was in the MLS. So as a listing agent, make sure you're putting right stuff in the MLS, but just know as a buyer's agent, just because the listing agent said the big screen TV in the bonus room conveys, that doesn't mean it conveys. Okay. What's listed in the contract, whether it's a fixture or personal property, that is what counts. The other thing to know about the fixtures listed in the contract is that not all of these things are actually legally fixtures, but it doesn't matter. The fact that it is listed here as a fixture that conveys makes it, by virtue of contract, a fixture. Okay. And the perfect example of that is a bathroom mirror that is hanging, is a free hanging bathroom mirror. That is personal property by statute, by law, not by statute, I guess, but by the definition of personal property, that is personal property. But because it's in the contract right here, mirrors attached to walls, ceilings, cabinets, or doors, and all bathroom wall mirrors, regardless of how they're attached. All right. So that personal property became a fixture because it's in here. I just bring that up because some of you are really smart and you might know the legal definition of a fixture. And you could be like, well, the mirror in the bathroom is not a fixture because it was not permanently attached. And the intention was not to leave it to be attached, because intention, by the way, has a lot to do with whether something's a fixture or personal property. What was the intention of the person at the time that they installed it? That matters from a legal perspective. Not anymore because it's written right here. Okay. So that's important. Make sure you and your clients are reading through this. My favorite phrase, and I'm skipping ahead because I'll normally say it with personal property, but when in doubt, write it out. Okay. If a seller does not intend to leave the TV mounts, because TV mounts are fixtures, the TV isn't, but the TV mount is, and the seller plans to take it, and you talk to the buyer agent, and buyer agent says, yeah, buyers don't care. They don't even watch TV in the living room. They're not going to put a TV up. I don't care. You need to write that out because the plans could change, and all of a sudden that TV mount is left in the house, and the buyer's ticked off about it, and you're like, well, we didn't put it in the contract that the fixture was excluded, so make sure you put it in there. But also, guess what? When you exclude a fixture, that then obligates the seller to repair any damage caused by removing it. So you need to have it in the contract so that when the seller takes that mount off the wall and there's 4 quarter-size holes in there, that the seller is obligated to repair that. Now, by the way, let's really have fun with this. Does the buyer care what it looks like after it's repaired? Would you care? Yeah, they care, right? You know what doesn't care? This contract as it's written. It just tells them to repair it in a workmanlike manner. But what's a workmanlike manner? That doesn't mean repainting the whole wall. That means patching, sanding, maybe touch up paint. But now you have 4 little squares where they touched up the paint. Seller did their job, and most people would argue it was a workmanlike manner. It's just not to the standard that the buyer might want. So if the buyer wants the holes patched, sanded, and painted, but they want the whole wall painted so that it looks good, then you need to use the additional provisions addendum. Go back to that paragraph where you could write in what you want the seller to do. When in doubt, write it out. Make sure you are talking with your buyer about what their expectations are. All right. I've got something here I wanted to make sure I touched on. Let me see. I just want to mention about them, the reason to continue reading through this section of fixtures. This gets updated. Like almost every year, there are some changes to it. It's because there are new complaints and new litigation that causes the forms committee to say, I never thought that somebody would get bent out of shape about a bathroom mirror that cost $39.99 from Home Goods. But sure enough, they did. Let's add it in there. And so there's new stuff that gets added, removed, and changed. So you just want to make sure you're always reading it, because something that you didn't think was in there before now all of a sudden is, and vice versa. All right, let's keep moving through quickly. Sellers have an obligation to unpair all of their smart connections. Make sure they're aware of that. If an item is leased, like a propane tank, it cannot convey. So make sure this section here, it says items leased or not owned, what is not conveying. Because a buried propane tank, well, that would be a fixture, except the seller doesn't own it. So it's not theirs to convey. So that needs to be itemized here. There could be other things that fall into that category. Solar panels well, solar panels probably isn't a good. I mean, I don't know. Maybe people do lease it. People have started leasing HVAC equipment. I mean, there's all kinds of stuff out there. You just make sure you're aware of what is leased versus what's owned. And if it's not owned, you need to exclude it here if it's included in this fixture section. Now, one note on that, especially with propane tanks, a common situation is propane tank is leased, but the buyer doesn't want to you don't want to have the propane tank removed and you got to get another company. A lot of times the buyer just wants to take over that lease. Great. That's the easiest way to do it. But we don't have a way to document that. You need to have an attorney draft that up and just make it clear. Let an attorney who's smarter than us, if you're not watching, I did it in air quotes. Let them draft that up on how to do that. Because if it's a reasonable buyer and seller, we don't even need this paperwork if we had reasonable buyers and sellers. We don't even need this 14-page offer to purchase because they're just going to treat each other right and do the right thing. But we do have this because people don't behave that way. And so let's not assume that it's going to be an easy handoff to change this lease over to the buyer. Let's let an attorney document that. They will have like a standard way of doing that. It'll be easy. All right, we talked about that. Personal property, when in doubt, write it out. By the way, there's no harm, even though you as a listing agent might roll your eyes, there's no harm in a buyer agent listing stove, dishwasher, whatever. It's okay to list a fixture in the personal property section. It just adds more clarity. It's okay. When in doubt, write it out. And if you need more room, add an additional page. Say, see attached personal property addendum. And then you list out everything you're unsure about, but that the buyer wants to convey. All right. The due diligence process, I already mentioned this, but I'll reiterate it here. The buyer can continue conducting due diligence after the due diligence period ends. Sometimes you'll need to take a deep breath and gently remind the other side of that. We talked a lot about the due diligence period and earnest money. Let's get into subparagraph C here. Just because a buyer has a house to sell does not make the offer contingent. Now, in North Carolina, we may think that's really obvious, but a first-time buyer, well, their first time buyer not going to be selling. If a buyer is from out of state, other states have contingent sale addendums. We do not. A buyer may read this section, and when you down here are going to check that they have a house to sell, no matter what this reads, and no matter what you tell them, they may think this offer is contingent on my house selling. It is not. We don't have a standard contingent addendum. North Carolina may reintroduce it. They may reintroduce it this year. I don't know yet. But right now, we don't have one. So the offer is not contingent. It is important that you stress that because they may be coming from a state where it is totally different. So be aware of what their past experiences could be. All right, subparagraph D. If you ever wondered, let me scroll back up. If you ever wondered where our contract says the house is sold as is, which it doesn't actually say that, it says the property is sold in its current condition as of the time of offer. But this is where it says it. Paragraph 4, subparagraph D, property is being sold in its current condition. Subparagraph E, buyers, if you break it, you fix it. So it just says that buyer's responsible for any damage that they cause. Guess what? Guess who you're also responsible for? The buyer's children. So when the children are in the house, don't let them just roam free. You're responsible for the house, even if that means an uncomfortable conversation about your client's reckless children. Because if your buyer is refusing to break it or to fix it or pay for it, guess who they're coming after? You, because you were the steward of that house while you were showing it. All right, paragraph H. If the buyer closes, they are accepting the property as is. Just remember that you need to settle all issues in writing prior to signing on that dotted line. If there's an issue at the final walkthrough, don't take anybody's word for it. The agent telling you, "Oh, don't worry, I'll get my painter over there. I'll do blah blah blah." Have the attorney draft something up. If the buyer closes, the buyer is accepting the property in its condition, unless there's something else in writing. Section 5 about the type of loan the buyer is getting or how they're buying the house. Just know that the contract is not contingent on the information you put here. However, you are expected to fill this out truthfully. Lying here can potentially make this contract void. If the contract was entered into on false pretenses, meaning the seller accepted it because the buyer said they were going to pay cash, but then the buyer turns out they don't have any cash. Like, not only are they not buying it in cash, but there is no world in which they would be able financially to buy it in cash. Then that potentially could void the contract if the seller wanted to. Now, the buyer can change and get a loan. But if that assumes they had the ability to pay cash in the first place, and then they just later decided to get a loan, they can do that. And there's not a darn thing the seller can do about it. But you do need to tell the other side. You need to keep the other side. You need to treat them fairly and honestly. You need to keep them abreast of what's happening. But a buyer can switch back and forth between loan and cash. Just remember, if a buyer is switching to a government loan where they need the seller to sign something, seller doesn't have to sign that. So fill this out truthfully. But if it changes, that doesn't make the buyer in breach. It doesn't cause an ethical issue with you. Again, we talked about the contract is not contingent. But you need to fill that information out truthfully. Where am I? I want to make sure. Okay, I didn't put it in my notes. As it pertains to subparagraph D here with the property disclosures, the RPD and the MOG, just make sure you're paying attention to that. Like, a crafty buyer's agent may check the middle box, which says they haven't received it, which gives them a 3-day right of rescission. Okay. Make sure that box is being checked that they have received it if you're a listing agent. And if you're a buyer agent, I don't know. I don't think that's like, you're not impressing me with your strategy if you have a copy of the property disclosure and you're marking that you did not receive it. Because if anybody can prove that you did in fact receive it, this is going to be a non-issue anyway. Just try to get this stuff before you make your offer. And as a listing agent, make sure you give it to them before they make their offer. That way there's no, because if they haven't received it, they get a 3-day right of rescission to back out and get their money back. All right. All right. Paragraph 6, that's straightforward. Buyer obligations. Just read through that if you have any questions. Paragraph 7, the first thing you'll notice is there's a box here that they can check for ownership, that seller does not yet own the property. So I'll just touch on that. Yes, that is real. A seller can sell it, can go under contract, before they own it. If that is happening, though, there are other hoops you're going to need to jump through. We're going to need to know that the person who does own it is giving permission for us to have an inspection, for example. The person who fills out their residential property disclosure, that is the person who has a deeded interest in the property. We're not talking about that form today, but that is a deeded interest in the property. That's not necessarily all the owners, by the way, that have to sign the property disclosure. Little known fact, only those who have a deeded interest. But let's say a wholesaler is selling the property. They don't have a deeded interest. They're not going to fill out the property disclosure. Is the seller even aware of what's happening with this transaction? Because we need a property disclosure from them. Or both parties can just agree not to do a property disclosure. That is one of the exceptions. A buyer and seller can say, yeah, you know what, I'm okay without one. And that could happen too. But just be aware of that reality that a seller doesn't technically have to own the property yet. Here's a big one that a lot of people don't realize. Failure to include the lead-based paint addendum on a home built prior to 1978 can invalidate the contract. Doesn't just create a problem with the loan later if a buyer is getting a loan. It can invalidate this contract. So don't let that one slip through. That is federal law that you have to provide that. All right, what else I want to touch on here? This is a good one. Let me move down here to the fuel tank. So of course you're going to be listing if there's a propane tank, who owns it? Is it above ground? What type of fuel is it? All that kind of stuff. Here's an important thing that changed a few years ago. It used to be common practice, sadly, that a seller, when they had propane in their tank, they would say to the buyer, like a week before closing, hey, I've got a tank that's 3/4 full. Do you want to buy that fuel from me? Because if not, I'm just going to sell it back to the propane company. And the contract let them do that because all the contract said was seller had to provide working utilities. So you just had to have enough propane in there to like test the heat. Now, after lots of complaints, probably lawsuits, the contract addresses that whatever propane is in there at the time of the offer, minus normal usage, is expected to be there at closing. It is included in the purchase price. The seller cannot go sell their propane back to the propane company, or they will be the one in breach of contract. An important point to know. All right, that's all I got for you in paragraph 7. Let's talk quickly about seller obligations. Seller has to provide reasonable access. This comes up more often than I wish it did. What does reasonable access mean? I have no idea what it means. But if there is a serious dispute about whether or not somebody's getting reasonable access to the house, you need to talk to an attorney. Does a buyer have a right to show up every day to show a different family member? I'd say no. But does a seller have a right not to let the buyer in one time to take measurements for curtains? I'd say no. They have to let him in they may have to let him in for more than inspections. What is reasonable? That is not up for you and I to decide. Just make sure you let a seller know, hey, look, you're not letting them in for anything. That could be a problem. You need to talk to an attorney before drawing a hard line here. Just be aware of that. We aren't the decision makers. We're the ones letting them know there could be an issue. Seller has to remove all the personal property, debris, trash, or they're at risk of breaching the contract. You'd hate to have the buyer be able to back out and get all their money back because a seller wouldn't remove their stupid old couch from the garage, right? So, would a judge uphold that? A couch? I don't know. But again, not for us to decide. Everything's got to be out, including all the crap in the attic that they don't feel like hauling down. Too bad. Got to be gone. If you see it up there as a buyer's agent, please bring it up to the listing agent early in the process. Hey, I know the seller has 50 years worth of stuff up in that attic that has like just a scuttle hole. It's not even a ladder. I know it's going to be a pain for them to get down. It's important to the buyer. Please make sure there's a plan for that. Important. I'll do a daily video on this if I haven't before. The survey, issues that show up on a survey survive closing. That is part, it doesn't exactly say that, I'm paraphrasing, but that is part of our contract here. If you look under seller obligations. So if one of as far as delivering good title. So if surveys are hard to get back within a due diligence period often. And the concern is, well, what if something shows up? Like my opportunity is during the due diligence period. Let's assume there's a lot of earnest money, okay, for the sake of discussion. But if there's an issue on a survey, now there are certain exclusions in here, such as like utility easements. There are certain things that will show up on a survey that do not count as title issues. But if there is an encroachment, for example, that is an issue that survives due diligence. So most of the time, it is okay that the survey comes back after due diligence ends, after the earnest money is non-refundable, because if there is a title issue discovered and the seller cannot remedy it, then they are in breach of contract. The buyer is owed their money back anyway. Okay, so just know that in the back of your mind. Get the survey back as quickly as you can, but it's okay if it comes back after due diligence. Governmental compliance, I'll be brief. We've talked about this many times. Think of it as this. Let's say that buyer discovers during their due diligence that the bonus room was finished and unpermitted, and it was never disclosed to them. That is a governmental compliance issue. But the seller has the right to remedy that. So they can go get it permitted, and then the buyer can't just say, well, but it wasn't permitted, so I'm backing out. Nope. Seller has the right to remedy that situation. So just be aware of that. But if they don't, then a buyer has a right to terminate based on governmental compliance. It is not always going to be cut and dry. I don't know how much this provision has been tested in court. I have no idea. This is why attorneys need to get involved. If you always try to just get buyers and sellers to agree to a decision. It doesn't matter what's in the contract if buyers and sellers agree to a decision. It's when they can't that we don't get to make determinations. We have to send them off to an attorney who hopefully knows about any precedence that has been created over the last few years. I just did a video on this recently. I'm not going to touch on it much, and it's not a huge deal if you do put the buyer's name in here, but when you're putting who the deed is going to be made out to, you do not need to put the buyer's name in there. This whole paragraph, if you read it, says as long as the deed is being made out to the buyer or to a direct family member or an entity that the buyer owns, then you don't need to put anything here. It's only if it's to somebody else or something else, then you need to put it in here because the attorney needs to know. This paragraph, in North Carolina changed the way they had this paragraph because they basically said, buyers, you need to just talk to the closing attorney and tell them how the deed is going to be made out. We don't want the closing attorneys to rely on this contract to make that determination. Buyer agents, buyers, tell the attorney who to make it out to. So if you get an offer and this is blank, that is fine. If you send an offer and this is blank, that is fine. Don't make a mountain out of a molehill. If a listing agent says, hey, I need you to put the buyer's name here, you can decide if you're in the mood to explain it to them or not. Maybe you'll just put the buyer's name in there. Okay. It's not a compliance issue for us. All right. Anything here I want to touch on? Oh, if there's any special assessments, usually special assessments are HOA related. I suppose there could be a tax assessment, but usually it's HOA related. If it's approved before closing, not before the offer, but before closing, it's the seller responsibility. If it's approved after closing, it's the buyer responsibility. I have negotiated situations before where there was a proposed assessment and we held money back in escrow so that if that proposed assessment got approved after closing in some window of time, the seller would pay it. So there are creative workarounds if there's a proposed assessment. All right, paragraph 9. Seller pays HOA fees for transferring the property to the buyer. So getting it ready to go into the buyer's name, that's a seller cost. However, if the lender is requiring something from the HOA, that's a buyer cost. So just a little nuance there. Nothing different than what you're used to with every closing that you've had that has an HOA. A seller has been responsible for that fee for, I don't know, maybe the last 10 years or so. Before that, it was a buyer responsibility. So if you ever have a seller client saying like, hey, I feel like I paid that when I bought this house 15 years ago. Like, yep, you did. North Carolina changed the law in the meantime, or changed the contract in the meantime. I don't think it's a law. Paragraph 10, what do I want to say here? As far as prorations, let the attorney's going to handle prorations, but it is still your responsibility to check that. We have an obligation to check the CD to make sure it's accurate. So check their prorations. Remember, seller owns the day of closing. So when you're calculating prorations, they owe the prorations through closing, not to closing. So they own the day of closing. Think of it as that expression. That'll help you remember it. Paragraph 11. Couple quick points here. The property has to be in the same or better condition at closing as it was at the time of offer. If not, the seller is in breach and buyer would get their money back. If there was a serious damage, like there was a fire, again, buyer and seller got to decide, do they still want to do this transaction or not? But if they do, and the seller receives an insurance payout, the buyer is entitled to that insurance payout in lieu of the property being repaired. So just be aware of that. It's not always like a catastrophic fire. It could be a sink leaked upstairs and there's a $2,000 insurance claim. The buyer can just accept that money that if they want to keep moving forward to closing. All right, paragraph 12, we know we have a 7-day right to delay closing. However, that is not just for fun. This is not meant for a buyer or seller to just say, yeah, I feel like the seller ticked me off during the negotiations. I'm going to just delay it 7 days to stick it to them. A buyer could be in breach of contract if that's what they're doing, and vice versa. A seller could be too. There needs to be a bona fide reason why they cannot close. They need to be unable to close, not just choosing not to close. Now, in a real world, I mean, what are you going to do? By the time you could get an attorney and sue somebody over it, you will have already closed on the property, right? You will have just been inconvenienced by 7 days and closed on it. But if you got somebody that's really upset about that and thinks the other side is being punitive by delaying, they need to talk to an attorney. Okay. Paragraph 13 talks about the different options for possession. We're not going to go into that. We'll talk about that on a different day. As far as buyer possession or seller possession after closing. Paragraph 14, this is where we talked about you need to make sure you're itemizing addenda. The one thing I want to point out here is do not, just because there are blank lines here, that does not give you the right to write whatever you want in here. So when agents are just writing stuff, they want some additional thing in here. No, you need to have an attorney draft that addendum and itemize it here. Don't write whatever you are wanting done into this section just because there's a blank line. It is literally only for attorney drafted addenda or party drafted addenda. Which, by the way, Form 220, guess what? Drafted by an attorney. But the buyer and seller can do whatever they want. So they can draft any addendum they want. No problem. All right, I'm going to skip all the way down to our contracts are not assignable. So that's pretty straightforward. And then, quickly, 1031 exchanges. We often get asked if there's a special form for that. No, it's already addressed in the offer to purchase. Seller has to cooperate with the 1031 exchange. You can't do anything to obligate them to pay anything related to it, but anything they need to sign, they are agreeing to do that for a 1031 tax deferred exchange. And then I'll move on down. Last thing to paragraph 23. If a buyer breaches the contract, just a reminder, the only remedy to the seller is, I say only, I'm not an attorney, but per the contract, the remedy to the seller is keeping the due diligence fee and the earnest money. Even if the buyer terminates on the day of closing, that's what they get. If the seller breaches the contract, they have to refund the due diligence fee and earnest money and any actual cost that the buyer has incurred. Or the buyer can sue them, right? I mean, if the seller tries to breach, a buyer can retain legal counsel and sue for specific performance. The last thing I'll say is that our contracts all say that the winning party, if they have to go to court, is entitled to attorney fees. But I will tell you from my experience and from hearing from lots of attorneys, North Carolina ain't going to give you attorney fees. So just know that. It's not like you need to be some legal scholar here talking to your clients, but you should just be at least loosely aware that North Carolina, precedents in North Carolina is that judges very rarely will grant attorney fees to the winning party. So just be aware. Could happen, but there you go. And I think that is all I got for you. Man, thank you guys for hanging in. This went longer than expected, but that's probably good. I added some additional forms in than what I had initially intended to do. I appreciate you guys hanging in there with me. I will wrap up this recording now. And probably, just like the rest of you, are ready to get on with your day. So are there any last questions about any of this? And I will hang out if you have some additional questions. Otherwise, you're free to go.